So this is the review for the fourth and final test. Please pay close attention to this review. It is comprehensive. Almost everything you need to know is on this review. So there will be 33 objective questions. 2 of those questions are matching, so they have multiple parts. The topics, of course, are wills and estates, zoning, constitutional issues, environmental law, and mold. But again, please pay close attention to this review. This is what you need to know for the test. All right, so we talked about wills, and you learned that there are several different types of wills, and a tested will is one that has witnesses. In Virginia, you must be 18 years old to write a will, and 2 witnesses to the testator's signature are required to have a valid will. A holographic will is a perfectly valid will in Virginia. It's all in the testator's own handwriting. So it's all in your own handwriting. No printed words, no typed words, all in the testator's own handwriting. Witnesses are not required for a holographic will. And then finally, you learn that there's an oral will, also known as a sailor's and soldier's will, and this is valid during the time of war. It only conveys personal property, not real property. Some other terms that will be on the test, and you must know: if you die without a will, it said the term is to die intestate. If you die testate, that means you die with a will, and of course, the person who has written the will is the testator. All right, so here's some other terms. Again, intestate, dying without a will. A testator is a person who has a written will. A codicil, and this is on the test too, is a written document amending a will. The executor is the personal representative of the estate. And in probate, this person is allowed to be reimbursed for reasonable expenses and may receive compensation in the form of a commission. Usually this commission is 5%. And of course, with a will, an adopted child may inherit property just like a biological child of the testator. All right, so we talked a little bit about constitutional issues and zoning. So you need to remember that if you were going to open up a store, or you wanted to build a house someplace, to determine whether a location can be put to future use, one should examine the zoning ordinance. You also need to be able to identify a non-conforming use, so that when the use of land is in conflict with a zoning ordinance at the time the zoning ordinance goes into effect, the non-conforming use has a constitutional right to continue. However, if that use ceases for 6 months, it's deemed abandoned. All right, so here's your example. Let's say that you own a bar on High Street, Mulligan's, and a zoning ordinance has passed that says no bars on High Street. Now, you decide that you are so successful that you want to renovate your bar, and so you close down, and the renovations take 7 months, and then you try to open up again. Do you have the right to continue the non-conforming use? And the answer, of course, is no, you abandoned it. So if it ceases, if the non-conforming use ceases for 6 months, it's deemed abandoned. And then, of course, a variance is where your use of the property is not in accordance with the zoning regulation. And if you are issued a variance, this is permits a landowner to use property in a way that is strictly prohibited by existing zoning. And you have to know that. All right, restrictive covenants are private restrictions on your use of property. They're found in deeds, and they pass from one owner to the next. Restrictive covenants are strictly construed. All right, so you may remember in class we talked about Mary is in a subdivision, and the homeowners association has a restriction that's in everyone's deed that says no pole-mounted satellite dishes. Well, Mary doesn't have a pole-mounted satellite dish. She has her satellite dish mounted on her roof. Is this in conflict with the restrictive covenant? And the answer is no. Their restrictive covenant only restricted pole-mounted satellite dishes. Mary's is on her roof. So the point of the case is this, that Restrictive covenants are often found in deeds, and they are strictly construed against the person who wrote them. So here's some examples of lawful deed restrictions that you could find. So a lawful deed restriction could be the type of building allowed on a property or building materials that you may use, acceptable paint colors, maximum or minimum size of houses to be built, setbacks, lot setback rules, and activities that may be conducted on the premises. These are just a sample. This is just a sample of some of the restrictions that you could have. All right, constitutional issues. Eminent domain. We discussed eminent domain in this class and discussed a couple of different cases. An eminent domain is where the government takes private property for a public use. Now, before a condemnation suit is initiated, the government must exercise a genuine but ineffective effort to purchase that property before you're actually sued and taken to court and forced to sell your property. A landowner pursuant to eminent domain must be compensated, and the compensation is fair market value at the time of taking. So we talked about the Supreme Court, Suzette Kelo, who took her case to the Supreme Court of the United States. And the Kelo case was somewhat of a disappointing decision. This case does allow the government to exercise eminent domain and then convey the property to a private developer for a higher and better use. Fair housing laws. Under the fair housing laws, you may not discriminate on the basis of race, color, religion, national origin, sex, or elderliness. In Virginia, elderliness is 55 and above, familial status, and handicap. It is illegal for a real estate licensee to be involved in discriminatory housing practices, and of course you need to remember that. And failure to comply with fair housing laws can result in fines, penalties, suspension, or even forfeiture of a real estate license. Age and family status. All right, so families with children, and a child is someone who is under the age of 18, families are protected under the fair housing laws. So it is illegal to advertise a preference for a certain number of children. So what you may see on the test is a case, a hypothetical, where Mabel is an elderly lady who also is terminally ill, and she has an anxiety disorder, and noise bothers her. There's an apartment next to hers that is open, and she asks the landlord, please do not rent this apartment to a family with children. Is this lawful? And the answer, of course, is no, it is not. This would be a discriminatory housing. Now, it is possible for property to qualify as housing for older persons and to be exempt from family status protection. However, a property may not be advertised for adults only. Now, in the Virginia Fair Housing Law, as I said earlier, elderly is defined as a person who has reached their 55th birthday. All right, disabilities. So landlord accommodations may be necessary under the Americans with Disabilities Act. A disability could be a physical or mental impairment. AIDS has been deemed to be a disability. A drug addict that is currently using drugs would not be protected. This is not a protected class. It's not deemed to be a disability. However, a landlord may not discriminate against someone who is in addiction recovery program. So if you are in recovery, then you may not be discriminated against in housing. You may, or a landlord may, discriminate against someone who has been convicted of trafficking, that is manufacturing or selling drugs. Advertising. Ads must not contain language that discriminates. So let's look at a couple of them. How about this ad? A student is looking for a roommate, and the ad says, females only need apply. This would be a legal ad. It's perfectly okay. But how about this? An ad says, Christian females only need apply. Would that be legal? And the answer is no. That would be deemed to be discriminatory. Asbestos. So we talked a little bit about environmental problems. Asbestos can cause or exacerbate respiratory diseases. Before 1978, it was found in most homes in lots of different types of building materials. Ceiling tiles, popcorn ceilings, siding, you name it. HUD does not require that asbestos be removed. You have to be really careful when you remove asbestos because the removal may actually cause further contamination. So it's expensive to remove asbestos, and you would have to use a state licensed technician and dispose of the asbestos in an appropriate or designated spot. Now, because of that, many homeowners or many businesses choose to encapsulate. So encapsulation is sealing asbestos, and this may actually be preferable to removing it. Lead-based paint. Lead-based paint, again, prior to 1978, is in most homes. Lead was used as a drying agent in oil paints. So the Lead-based Paint Hazard Reduction Act requires landlords and sellers of houses built before 1978 to make certain disclosures. So here they are. Seller must disclose the existence of lead-based paint. Landlords must disclose the existence of lead-based paint. And real estate licensees must give buyers and lessees a pamphlet entitled Protect Your Family from Lead-Based Paint. Lead in your home, Protect your family from lead in your home. There's potential liability if this pamphlet is not given to prospective buyers and lessees, and we've seen fines of up to $20,000 for failing to provide this lead-based paint pamphlet. Radon is an odorless, colorless gas. It is naturally occurring, and the only way you can determine whether radon is present is to test for it. You have to do a specific test for radon. There's a potential link to cancer, and it causes the greatest harm when it's trapped in concentrated amounts in inadequately ventilated areas. So the easiest remedy is to open windows and to increase ventilation if you can. So open windows, that's it. Superfund tort liability. Now, we talked a little bit about environmental protection laws, and we talked about the Superfund liability. And remember, with Superfund liability is not limited to the current landowner. If you have ever owned or leased property that's now deemed to be a hazardous waste site or a Superfund site, there is joint and several and retroactive liability. So recall Jim Wilson and his car wash in Monterey, California. He hadn't even thought about this car wash in decades, and he was sent a bill by the EPA and wonders, do I owe it? Remember, his problem was that he dumped soapy water. It was not illegal at the time, but now it's created an environmental problem. So we also learned that there's one way that a potential homeowner or a potential property owner can protect themselves from liability for Superfund, and that is by being proactive and performing a Phase 1 site assessment. And so you would have someone come in and do this assessment and check to see if hazardous waste is present on the property. If not, you've done your due diligence and you may not be held liable. We also talked about mold, and moisture problems are the source of mold. So it's important to eliminate moisture, to implement a rigorous inspection program if you're a property owner, and to maintain your property and immediately respond to problems. Common causes of mold problems, and by the way, this is a multiple choice question, so this is easy. Improperly installed windows, leaks at thresholds or roofs, improper drainage. These are all common causes of moisture problems in a building. The Virginia Residential Landlord and Tenant Act says this, that the landlord has an affirmative duty to disclose the presence of mold, and the tenant has the right to terminate the tenancy if mold is present. Eminent domain. So in the Kelo versus City of New London case, the Supreme Court held that it is acceptable for a government to exercise eminent domain to take private property owned by one individual and sell it to another individual who is going to take it and use it for a higher and better use. Again, before a condemnation suit is initiated, a genuine but ineffective effort to purchase must be made, and the value is fair market value at the time of the taking. And then last but not least, historic preservation tax credits. There are federal historic preservation tax credits, and they include a 20% credit for qualified rehabilitation of a certified historic structure or a contributing property located in a registered historic district. There's also a 10% credit for a non-residential depreciable building first placed into service before 1936. Here's what you need to remember. A preservationist or a developer may not use both the 20% credit and the 10% credit on the same project. These credits are not available for a house used solely as a personal or private residence. And so that's it for your review. And this is the last test of the semester before the final exam. Best of luck. Thanks.